afternoon to everyone and welcome to Women's Day on the Hill. This is our very first virtual Women's Day and I'm excited about that. And I also want to wish everybody a very happy International Women's Day. For the women that are joined in, please give yourself a well-deserved applause and pat on the back. International Women's Day is our day to celebrate our accomplishments and hard work that only we as women can truly understand and identify with. And I encourage each and every one of you to take the time today to celebrate others as well as yourself. My name is Stephanie Williams, and as president of the Women's Political Collaborative, I thank you for your attendance and support of this event today. If you are unfamiliar with the Women's Political Collaborative, we are a bipartisan organization that seeks to educate and empower women so that women may become engaged and influenced in the political process. And we also collaborate with like-minded groups to impact women's policy and other important issues. I would like to encourage each and every one of you to support the collaborative by joining today. Membership allows you to support our efforts and our work and to have access to our programming at little to no cost and for a nominal fee of only $75 per year. You may join our organization by going to WPCTN.com. By way of example, not only do we have this program today that we are bringing to you, but this Friday, we will host another Lunch and Learn with historian Carol Busey, who will talk about forgotten women in Tennessee history. And it is free to attendees if you are in the legal profession and you would like CLE credit. CLE credit is $10 for members and $25 for non-members. Before we get started today with our program, I want to take a moment to shine a spotlight on our executive director, Joyce McDaniel. Joyce works tirelessly to come up with ideas for programming and coordinates all of it. When COVID brought many organizations to a standstill this time last year, Joyce really embraced technology and ramped up our programming to continue to serve the community through relevant, engaging, and informative programs, and even started a book club. I can't count the number of programs we've had over the past year. I'm sure they are well over 20, maybe 30. And through those programs, we have been very fortunate to attract a very inclusive and diverse audience, as well as panelists. Joyce has been very intentional about making sure that all voices are heard and the landscape of our diverse community is represented in our programming, and she has nailed it, and she continues to do so. So Joyce, on behalf of your board, I am here to take the time today to say thank you. In addition to Joyce, today's event is made possible with the collaboration of many organizations, including Emerge Tennessee, Awake, Advocates for Women and Kids Equality, Hadassah, the Sexual Assault Center, the National Coalition of Black Women Nashville Chapter, the Tennessee Justice Center, the National Council of Jewish Women, Women in Numbers, Lawyers Association for Women, AAUW of Tennessee, Tennessee Coalition to End Domestic and Sexual Violence, the Davidson County Democratic Women, YWCA of Nashville and Middle Tennessee, Moms Demand Action, Planned Parenthood, and Greater Chattanooga Women's Fund. Thank you all for the works that you do on behalf of our community and for your collaboration with the Women's Political Collaborative today and throughout the year. For our program today, we have a treat of a panel for you that will discuss victims' rights in Tennessee, in the Tennessee criminal justice system. Are we doing enough? Our panel will be moderated by WPC President-elect Jenny Charles. Since graduating from the University of Memphis Law School in 2006, Jenny has worked as an assistant public defender and in-house counsel for the Davidson County Sheriff's Office and as an assistant district attorney. While in high school, Jenny was the victim of an aggravated robbery, and the case was accepted for appeal by the Tennessee Supreme Court on eyewitness identification. Jenny enjoys all things true crime and is an inspiring writer, although she doesn't do as much aspiring as she should. Join the club, Jenny. Thank you, Jenny, for your service to the Women's Political Collaborative and in our criminal justice system, and for working with Joyce to put this panel together. This is going to be so much fun. I'm going to go ahead and introduce our panelists at this point. We will start off with Kathy Walsh, who we just heard from a little while ago. Kathy is the Executive Director of the Tennessee Coalition to End Domestic and Sexual Violence. As a leading voice for survivors, Kathy fosters statewide partnerships, develops effective programs, and advocates for social change to end violence against women and girls. Working with survivors, advocates, and policymakers over the last 3 decades, thank you, Kathy. Kathy has helped craft more than 200 new laws, improving victim safety and offender accountability. Next, we have Mary Dobbs, who works as the assistant designer for a staging and design company in South Nashville. She considers herself bi-coastal as she grew up on both sides of the country and moved to Nashville in 2006. In 2017, Mallory was a victim of stalking in the Vanderbilt area by a sex offender with 14 prior felony convictions. Thank you, Mallory, for joining us today. Then we have Susanna McKinney, who joined Marcy's Law for Tennessee as the Director of Public Safety in March of 2020. After graduating from Wheaton College in 2014, she began her career in Birmingham, Alabama, working in public policy and economic development, moving to Washington, D.C. in 2016 and joining the Justice Department. At the Justice Department, she worked in the Office of the Attorney General as a special assistant and then Office of Legal Affairs, in the Office of Legal Affairs as an intergovernmental liaison. Susanna, thank you for joining us today and for joining this panel. And last but not least, we have General Amy Weirich, who currently serves as the District Attorney General of the 30th Judicial District. She was first appointed to that position in 2011 by Governor Haslam and then subsequently elected in 2012 and re-elected in 2014. With over 30 years of experience, she sees her work as a prosecutor as an opportunity to work with incredible people and to do a job that simply requires her to do the right thing every day for the right reason. And I have to believe that she is in the minority in terms of being a female attorney general in our state. So what a treat to have you with us today, Amy. Thank you so much for joining us. And I will go ahead and turn things over to Jenny at this time. Thank you all.
All right, good afternoon, everyone. For the next hour, we will address what rights victims currently enjoy in Tennessee's criminal justice system and address areas where some say there is room for improvement. We're going to spend some time unpacking Marcy's Law, which is a proposed amendment to the Tennessee Constitution. We're also going to touch upon the topics of restorative justice and truth in sentencing. And I knew we were going to talk about victims' rights, so I thought it was very important to hear from an actual victim. So Mallory Dobbs is with us on her lunch break to share her experience navigating Nashville's criminal justice system. There will be an opportunity at the end to ask some questions of our panelists. So if you think of something you would like to ask, if you would just use that chat feature and send it to Jenny Charles. So let's get right into it. Every legislative session, the Tennessee Coalition to End Domestic and Sexual Violence, as well as the District Attorney's Conference, are definitely in the know as to what legislation is gaining traction on the criminal justice system. So I'd first like to hear from Kathy Walsh and District Attorney Weirich, and if each of you could just give us a brief synopsis of your current legislative priorities this session.
I'm happy. Amy, do you want to go first, or would you like for me to go?
I'm happy to. Sure,
Okay.
I'm happy to go first. First of all, thank you for allowing me to appear today and talk about these very important issues. It's great to see some familiar faces and see lots of new faces. So currently, I am the district attorney for Shelby County. As you heard, I'm also this year's president of the Tennessee District Attorney General's Conference. There are 31 elected district attorneys from across the state. 4 of us are women. And our legislative packet for this year focuses on 2 very important buckets. First of all, victim services. How can we improve in the state of Tennessee through legislation, through statutory changes, the services that we provide to victims and the process that victims have to go through. And I know Mallory is going to share some of her experience with us later. The other big bucket that our agenda fits into is truth in sentencing. And I think when you heard Mallory's introduction, I've been doing this for 30 years and it still causes me to raise my eyebrows when I hear something like he had 14 prior convictions, because everybody on the screen was probably wondering, well, what in the world was he doing out and able to victimize Miss Dobbs? Why was he even out of custody? And the answer to that is we have no truth in sentencing in the state of Tennessee, and we need it. Victims of crime deserve to know how much time their offender is going to be sentenced to, and defendants have a right to know how much time they are going to be sentenced to. Earlier this morning, I was responding to an inquiry about why somebody was released this month when they pled guilty to 15 years in August. And believe me, when we find the answer to that very disturbing question, I'll share the disturbing answer with you guys. But the short answer is there's no truth in sentencing. And 15 years in the state system can mean a variety of different things. So that's what our agenda is focused on: truth in sentencing, victim services. One of the examples of our victim services agenda items is safe spaces in every courthouse, right? For those of you that have been a victim of a crime, depending on where that crime occurred, you might have had to sit in the courtroom next to the person who offended you or sit next to their family member. That's not right. And the victims of crime in Tennessee deserve better than that. So we are proposing a one-time county matching fund that would allow courthouses to avail themselves of those resources and allocate space that is dedicated to victims of crime, so that when you come to court, for the many times that you have to come before a case is over, you have a place to sit and wait where you're safe and where you are free from harassment and intimidation from the person that offended you. So that's just one example of about 7 or so legislative items that we have geared toward improving victim services. And with that, I will pass it to my good friend, Kathy Walsh.
Thank you, Amy. Let me just say that this year, the coalition is tracking around 300 bills, which are a lot. So we track bills related, anything that we think is going to impact survivors of domestic or sexual violence. And so there are a lot of been filed. One of our priorities this area, this session you've already heard about, is making improvements to the collection, storage, and tracking of rape kits. There's a couple of different bills on that that we are supporting. You heard about some of the other bills about victim confidentiality and so on. Over the years, I just want to say the Tennessee General Assembly has been excellent at passing laws to increase offender accountability and provide victim safety. I think we have some of the best laws in the country, but it's not just passing laws, it is also implementing those laws and educating people in the system about the laws. You know, one thing I think we need to look at in Tennessee is that we really need more resources for victims. Part of victims' rights is ensuring that you have safety, that you have shelter, that you have food, that you can take care of yourself and your children. And I think those are the areas that we're really lacking in Tennessee. We have 38 domestic violence shelters in 95 counties. We have 12 programs, only 12 programs providing sexual assault services. You know, having more money for these services is so very important. I've seen survivors over and over and over again choose, you know, going back home to a batterer because they just don't have the resources to be on their own. It's a choice between feeding their children or, you know, going home to violence. And that should just never happen. So one of the areas I'd really like to see us begin focusing on is how do we create more resources so that victims have choices. They have that safety beyond what goes on in the courtroom. You know, what happens after an arrest? What happens after somebody goes to a shelter? We find every year when we survey programs that the number one unmet need for survivors of domestic violence in the state of Tennessee is housing whether that's emergency housing, transitional, more long-term housing, but housing is number one. And that's followed by legal assistance. So legal assistance with divorce and custody, civil areas that folks need legal assistance in. We need more funding so that we can provide those types of services for victims. I think that we've come a long way, and over the years, you know, the coalition has led the charge with expanding who can get an order of protection, access to orders of protection, stalking, more penalties for perpetrators, such as, you know, 24-hour hold, conditions of release, all those things that are important to victim safety, and human trafficking and confidentiality. All of these things are important so that victims can restore their lives. But again, if we don't have basic services in our communities, if we don't have resources for survivors, we are doing them a disservice. Thank you.
All right, thank you both for that. I want to wade into House Joint Resolution 44, and that is sponsored by Representative Patsy Hazelwood. And this is commonly referred to as Marcy's Law. And Marcy's Law is not a bill, rather it's a resolution. And if passed in 2 consecutive legislative sessions and signed by the governor, a constitutional amendment would be placed on the 2026 ballot for voters to approve. Now, Tennessee's Constitution currently dedicates 8 rights to crime victims, and we're going to take a look at those in a minute. But first, I want to hear from Susanna McKinney. Susanna, why does Tennessee need Marcy's Law?
Hey, Jenny. Hello, everybody. Thank you guys for letting me join you this morning. It's good to be with you. Marcy's Law is a law named after Marcy Nicholas. She was a 21-year-old recent college grad who was stalked and murdered by an ex-boyfriend. A week after her death, her family was at the supermarket where they were confronted by her accused murderer, who had, unbeknownst to them, been released on bail. And as you can all, you know, take a second to imagine, this took what was already a nightmare and compounded the trauma immeasurably. You know, having, you know, your family terrorized by the person who ultimately was proven to have killed Marcy. And so anyways, her older brother made it his mission in life to provide for crime victims all over the country. And so he founded Marcy's Law in 2009. And since then, it has kicked off a victims' rights movement that has been adopted in, you know, a dozen different states, with, you know, some other states pending. And Tennessee, we hope to add to the list very soon. And it's, you know, good that you mentioned. A lot of folks are going to say, wait, don't we already have a Bill of Rights, a constitutional Bill of Rights for crime victims in Tennessee? And the answer is yes, we do. It was passed in 1998 originally and approved by 88% of Tennesseans. So this passed overwhelmingly in 1998, and it enumerates some lovely rights for crime victims. What we would like to do, how we would like to amend, because it's a constitutional amendment. So we are trying to amend the current Bill of Rights in several ways. Chief among them, the most important part of Marcy's Law and what we're trying to do in Tennessee is to make those rights enforceable. So as they're written right now, there is no means by which a victim can assert their rights. There is no recourse available to a victim if his or her rights are not upheld. And as we all know, the old adage, a right without a remedy is not a right at all. It's a suggestion. So we want to take this wonderful list of suggestions and we want to capitalize on all the pro-victim energy and sentiment and culture in Tennessee, and we want to make them official. We want to make them enforceable. We want to give victims legal standing by which they can stand up and speak for themselves in a court of law. So that's our mission. And that's what Representative Hazelwood and Senator Stevens are carrying HJR 44 for us in the legislature.
Thank you for that explanation, Susanna. I appreciate that. I'm going to share my screen now and attempt to put up the 8 rights that are currently enumerated in the Tennessee Constitution next to the proposed language changes that Marcy's Law would enact. And as I understand it, we have some visually impaired folks joining us. If you need we have this in a Microsoft Word document, which the font is much larger than this. So if you need that, if you would send through the chat link your email address, and I can get that to you. All right, so I want to start with number 1. So we've got the right to confer with the prosecution. Now, Marcy's Law would change that, albeit slightly, but it is a change. So the first right listed as it currently appears again, and all that means is a victim of a crime has the right to make their feelings known about what they want to see happen on the case to the lead prosecutor. Now, I can't speak for any other jurisdictions, but I know in Nashville, we have victim witness associates. We have, I want to say around 20 of them, whose job it is to call victims and let them know about court dates and get their feelings about the case. And sometimes they want to move full speed ahead and want justice to be served. And other times that includes not wanting to prosecute the case, even on very serious charges. So Susanna, let's go through some of these, beginning with number 1. What is the rationale behind that upon request language?
Sure. This is really helpful to have side-by-side language here. Marcy's Law, the proposed resolution, is the product of extensive collaboration. We've had input from the governor's office, the attorney general's office, to the district attorney general's conference, the Department of Safety, the Department of Corrections, and all of our law enforcement partners. So we're really proud of the language that we ended up with here. You're going to see a lot of repeated language. It looks a lot like the Bill of Rights that we currently have, which is by design, because we like those rights. We think there's a lot of goodness to build on there. So what this does, and it's important to note that the original language is as precise as they wanted it to be when passed, but without that enforcement piece, it's a little bit different in context. When Marcy's Law, if all of these rights are enforceable, we have to be very precise about what they mean and when they mean it. So upon request is something that you'll see added to several of these rights. And upon request, what that does is it takes this what is suggested, the right to confer with prosecution, is suggested in the original Bill of Rights. But now is an imperative. So a victim has the right and can assert it regardless of what else is going on. So we want to be very clear that upon request limits these rights to victims who actively want to participate. So their right to confer with prosecution, they have to stand up and say, I'd like to confer with the prosecution. If they don't do that, that is the way in which they claim into the right. The right upon request to reasonable notification of release, transfer, or escape. Again, a victim, to be entitled to that right, to enforce that right, has to stand up and say, I want that right. And here's my contact info, and here is what I want to say. So it's an active, it does not tie up resources chasing down victims who don't wish to participate, who really want to be done with it, and who don't want to linger with the criminal justice system. And it focuses on victims who express an active desire to assert their rights. So that's really important language that you see here in number 1, and also several rights that are subsequent.
Yeah, thank you for that. Staying on this first right, here, the right to confer with the prosecution. So we have a statute, and that's 4038-114. And under that statute, a victim does not have the right to, quote unquote, direct the prosecution. And what I take that to mean is if a prosecutor wants to settle a case in a manner that the victim disagrees with the defense attorney, the victim cannot override, so to speak, the prosecutor's decision. And additionally, if a victim is not conferred with by the prosecution, it doesn't affect the finality of an agreement between the prosecutor and the defense attorney. So would Marcy's Law seek to change that?
No. So Marcy's Law does not infringe on prosecutorial discretion, nor does it infringe on judicial discretion. This gives victims a participatory voice, not a veto. So the right to confer upon request does not equate to the right to influence prosecutorial strategy necessarily. Now, oftentimes, we are lucky to live in a state where prosecutors oftentimes collaborate with victims on these things and oftentimes are on the same page. But in the event that a prosecutor and a victim are on different pages, the prosecutor at the end of the day is the one who's trying the case. They are just obligated to confer with the victim if they so desire.
Okay. Number two, that Marcy's Law language seems to mirror the current right. However, it makes the addition, including reasonable protection from the accused or any person acting on behalf of the accused. So currently, if a victim wanted to seek an order of protection from the accused, they could obviously petition for that and go through a hearing. Susanna, what specific reasonable protections is Marcy's Law calling for? And do you anticipate any additional funding from the state needed to cover those protections?
Mm-hmm. One example that comes to mind where this right would come into play is in the event, and not limited to this event, but this is a good way to explain this. There are some crime victims who are harassed by their offenders from behind bars. We know a victim whose mother was murdered, and her mother's murderer from behind bars files frivolous lawsuits and makes threatening calls and sends out people that he's in jail with to come and seek her out after they're released. And all this does is this, again, if this right becomes constitutionally enforceable, this gives her the right to be free of harassment, just like that offender has a right to free speech. It just makes those rights equitable. It gives her a fighting chance to have her right to be free of harassment balanced against that right. So this is, this could be order of protections. This could be, the Department of Corrections revoking that offender's, right to make phone calls. Depending on the situation, this just puts some teeth into a victim's right to be free of harassment and intimidation and abuse.
Let's go down to number 6. Now, this is always a subject of contention, the right to a speedy trial or disposition and a prompt and final conclusion of the case after the conviction or sentence. So, continuances are part and parcel of the criminal justice system, just as I'm sure they are in the civil system. And sometimes they're really needed. Sometimes discovery comes in late and both parties need a continuance. Are continuances abused? Yes, they are. But how, explain to me sort of how this would be enforced. Would there be a time limit put on a particular case, or just kind of break this down for us?
Sure. So this is definitely in the case of abused continuances. This is in the case where an offender is changing defense counsels time and time again, and who is, filing for stays and for, deferences repeatedly. What this What this right does is it creates the legal footing for a judge to balance that offender's rights to a robust and healthy defense, balance their right, but also consider a victim's right to a speedy trial. Right now, because these rights are unenforceable, because there are no legal penalties attached to not upholding them, you create a lot of post-conviction appeal issues if you rule against an offender's very enforceable rights. Offenders have strong, robust, enforceable rights in the Constitution, as they should. That is for good reason. But because of how heavily they are weighted in the Constitution, they're very uniformly enforced. And because of victims' rights are not heavily weighted, in that if ever those two things bump up against each other, a victim's right to a speedy trial is almost never considered. And it's not because a judge or a prosecutor does not want to consider them. I sat in on a hearing just this year where there is a murder of a police officer from Dixon County on video, a gruesome, horrible murder. And this trial has a lot like many other cases, has languished and been deferred. And because of COVID, it's been, delayed some more. And at this hearing, a prosecutor argued passionately. He said, this victim, the victim of this family, deserves the right to a speedy trial. There is not a lot of guesswork here. These continuances are being abused. These are not legitimate reasons to postpone a case. And a judge very sympathetically said, I hear you. I agree with you. However, the law is on the side of the offender here. And it's not because that's necessarily the right thing in this instance. And in this instance, it would be incredible to have a constitutionally enforceable right of a victim to temper that. So this just creates the opportunity for a consideration of victims' rights, whereas right now there really isn't much contest. Does that answer your question?
Yeah, yes, it does. And I appreciate that. That was very detailed. Let's go to District Attorney Wyrick. Are there any comments or concerns with any of the proposed changes that Marcy's Law would bring if it's passed?
Well, and it gets back to what Kathy said from the beginning, and that is resources. So when you had that great visual up a minute ago of the side-by-side language of what's currently in the Tennessee Constitution and what this House Joint Resolution proposed, what the Marcy's Law change would add is the extension of all of those rights that you saw on the left-hand side to every case at the general sessions level and at the juvenile court level. Currently, when the current Victims' Bill of Rights was passed in 1998, it is applicable to cases post-indictment, okay? And for you non-lawyers on the screen, I'm not going to bore you with a criminal justice 101, but just let me give you a difference in what the numbers are. Currently, the Victims' Bill of Rights that we have in Tennessee, that we value and honor and reference and eloquently and passionately use in court every day, to the example Susanna was just giving you. There are prosecutors in court right now telling a criminal court judge here in Memphis, Your Honor, these victims have a right to a speedy trial. But what the Marcy's Law change would add to that is currently we have about 160,000 cases filed statewide that are indictment, right? That are indicted cases. Marcy's Law would apply to about 1 million cases. If you expand it to general sessions litigation as well as juvenile court, it would be an increase of 1 million or more cases that all of those rights would have to be, victims would have to be contacted and work would have to be done. The work that Susanna was talking about, all of that would have to be done on almost 900,000 more cases a year. So it's really the concepts behind Marcy's laws, the right to confer, to be present, to be informed, to be made whole. We're doing all of that every day in the courts throughout this state. The concern that we have is in the implication of and the extension of the language to the entire general sessions business in the state, as well as those juvenile court proceedings. Just as an example, the right for a victim to be present at a bail hearing at 2 o'clock in the morning when an arrest is made by the Memphis Police Department. How does that practically get done? Whose job is it to notify that victim of when that bail hearing is happening? How do we make sure that the bail hearing is put on pause or delayed until that victim can get there? Who's going to actually be doing that on those 900,000 plus more cases every year?
All right, I want to give Susanna a chance to respond to that. Susanna, what do you have to say about that?
Yes. Well, so in terms of numbers, we believe that the addition of upon request to these rights will distill that number down to victims who do truly want to actively participate. We are working on some numbers from other states to see how that percentage typically shakes out over time, how many victims choose to exercise those rights. But we don't anticipate to be the number of victims exercising those rights as there are total victims. We do anticipate there are a lot of victims who are like, I got my stuff back, or it was a misunderstanding, or, I mean, there's always going to be that. But more importantly, the expansion into juvenile crime, as we learned with our Lunch and Learn with Chief Frank a couple of weeks ago, which was great, juvenile crime is exploding, especially in the city of Nashville, but also statewide. And we believe that if you are the victim of a rape that is perpetrated, whether it's by a 60-year-old or a 16-year-old, you deserve the inherent right to participate in that justice process. Some of the A and B misdemeanors that are heavy in those general sessions dockets are felony crimes that have been pled down. And even crimes that start out as A and B misdemeanors, I mean, you're talking about violation of a protective order. You're talking about first, second, third domestic violent assaults. You're talking about sexual exploitation of the elderly. You're talking about a lot of crimes, that if your neighbor exposes himself to your 7-year-old daughter on purpose, you might want to know when he's going to court. And we're really excited about these changes because, coming from a federal perspective, I got the benefit of seeing all of the VOCA funding that is available for exactly these initiatives. Right now, our statewide notification system for victims that's used by 95 out of 95 sheriffs in the state of Tennessee, it's the SAVIN notification system. SAVIN notifications require or satisfy the requirements in Marcy's law, and SAVIN is currently funded by VOCA. So if we could find a way to provide software for free to general sessions court, to any kind of court notification systems, that can do the lion's share of the paperwork, that really frees up resources for one-on-one interface with victims throughout the process. But we are fully, we think that regardless of, why certain victims' rights are upheld and why others aren't, is not a nefarious problem. But we believe that the solution, regardless of why, starts with giving a voice to every single victim, should they choose to employ it. And that's just step one. Step two, 3, 4 is, if we need to look at how things are situated, if the General Assembly needs to provide some more funding, if indeed funding does prove to be an issue, we've got time. We've got a very long runway for this because, as Jenny mentioned earlier, it's 2026 at the earliest before this can be passed. So we're hopeful. We think this is in line with what the people of Tennessee probably assume is already happening based on what they voted overwhelmingly to support in 1998. And we believe that it's in line with what everybody deeply wants to be happening. So,
all right, thank you for both. Oh,
yeah, no, we appreciate
sorry, we got it. Yeah,
it.
thank you for both. Thank you so much for both of you for agreeing to weigh in on this. I want to make sure that we have enough time for the conversation on restorative justice and truth in sentencing. Now, I want to move to restorative justice, which can mean many different things, but the overarching principle behind it, as I understand it, is that crime causes harm and the criminal justice system should focus on repairing that harm. And this usually culminates in a meeting between the person who committed the crime and the victim. Now, the Tennessee Department of Corrections Victim Services provides a voluntary victim offender dialogue program. So if a victim desires to do so, they can actually have a face-to-face meeting with their offender. And I think we can all agree that if we can engender an empathetic response in a person who committed a crime, that's probably going to go a long way for public safety. However, I do think it needs to be victim-led. I imagine that some don't want to sit down with the person who hurt them. And on the flip side of that, I can imagine some offenders don't want to sit down with their victims. So I want to hear from Kathy Walsh on this first. Provided the victim of domestic violence has a desire to sit down with the person who hurt them, do you think there could ever be a place for restorative justice in the domestic violence arena?
Well, first, let me say, I absolutely believe that the survivor of the crime should be the one driving the boat. You know what I mean? Because what is justice for one person might look differently for another. I can speak personally, as a middle-class white woman, when I was abused, the justice system worked really well for me. But it doesn't work so well, as we know, for women of color, for people of color who go through our system. Sometimes we have victims who don't want to prosecute for lots and lots of different reasons. And so we never want anything that would force a victim to do something they don't want to do. And I can only speak from my experience, and what I know about domestic violence is that, perpetrators commit domestic abuse and sexual abuse because they can, because they feel entitled to do that. In my experience, they know exactly what they're doing. And so, restorative justice, part of that is about the victim being able to tell the perpetrator how that made them feel, what it was like to educate the perpetrator. Well, we have other ways to educate perpetrators, and we often use survivor panels in our training, in our community trainings, because we want to educate people on that. But I can just say, for a lot of victims of sexual violence and domestic violence, being in the same room with the perpetrator, hearing that perpetrator's voice can trigger them, and suddenly you feel that you are back in that same place at that same time experiencing that abuse. So I think for a lot of survivors, restorative justice would be something they would not choose to do. It might work better with other crimes where you haven't had that personal relationship or sometimes intimate relationships with the person. But if you've ever been in an experience where you really thought you were going to die, that changes you. That changes how you feel, how you look at the world, how you experience things, and little tiny things can trigger those feelings again. So I guess in closing to say, again, we want survivors of violence to have some choices, to be in charge on a personal level. I can't imagine that restorative justice would have been something I would have chosen to do.
Thank you for that. Let's go to District Attorney Wyrick. Is your office using the restorative justice model in any of the cases prosecuted in Shelby County? And what are your thoughts on the use of it in the criminal justice system?
Short answer, yes. We have had a very successful youth court program here in Shelby County for many, many years. And many of my prosecutors are involved in that in their free time. And that, you guys may have it in Davidson County and in other jurisdictions as well, but that is juvenile offenders being prosecuted, defended, and judged by their peers, by juveniles. And it has a great success rate in reducing recidivism. We are on the cusp of rolling out our community justice program on the adult side of things. And Kathy has hit on everything that we have struggled with in the last 2.5 to 3 years in building this program. And what we have designed, and we were supposed to kick it off tomorrow, but stupid COVID is messing things up again. We are offering community justice to low-level theft, low-level vandalism, burglary of a car, and non-intimate partner domestic violence cases. Those mothers and sons where the son is abusive to the mother and she doesn't want him to go to jail, she just wants it to stop. Those types of cases, we are farming those out to a community panel, 3 members of the community who have been trained and who have volunteered their time to hear these cases. But to Kathy's point, the victim has to agree to have the case handled that way. That is conversation number 1. We pick up the phone and we call that victim and say, hey, the person who did this to you is eligible for prosecution and handling in our community justice court. Is that okay with you? And the defendant has to agree to have the case handled that way. If they both agree, this community justice panel listens, again, with an eye toward making the victim whole, honoring that victim, but holding the offender accountable and rebuilding that community where that crime occurred, right? So I'll keep you guys posted on the success. We hope to have our first panel hearing this week, Thursday night. And I'll let you know how it goes, but it is very much victim-centered and they have to consent to having the case handled that way. If the offender successfully completes the program, I'm going to dismiss their charges and I'm going to expunge them from their record like it never happened. But it's going to be this community deciding what the quote unquote sentence should be. What should this offender be made to do? And going to prison is not one of the options. It's job training, it's anger management, it's counseling, it's life skills, whatever it is that is your obstacle to having a successful and productive life. The community where that crime occurred is going to be deciding it. And you're going to be, you're going to have to face that victim and hear how what you did to him or her impacted them. So I'll keep you guys posted.
Thank you for that. I want to hear from Mallory next. And I got to know Mallory because I was the prosecutor on her case. And in 2017, her world was pretty much turned upside down by a man named Timothy Temple. By the time Mr. Temple began to stalk Mallory at her home, he had 14 prior felony convictions. One of them was a sex offense. He had, I believe about a decade prior, attempted to rape a woman. And he had stalked upwards of 7 different women in the Vanderbilt area. Mr. Temple would bring a folding chair night after night and set it outside of Mallory's bedroom window. She eventually had to move out of her home until police could arrest him. And he wound up pleading guilty to the indictment and he got the maximum sentence of 9.5 years. And we're going to discuss that in a minute under the truth in sentencing portion of the program. But the 9.5-year sentence was far from 9.5 years to serve. So Mallory, while we're on the topic of restorative justice, you know, if the answer to this question is no, that's okay. But do you think in your situation, you would ever desire to have a face-to-face meeting with this man and talk about the crime?
I can see how that could be beneficial, but until it's like just thinking about it right now, I think the only reason why I was able to get over this without being like truly scarred is not even hearing his voice. If I don't know if I really actually would do that, the restorative, but I can see it being maybe useful, to get over something as a whole.
Sure. Can you give us an overview of what your experience was like as a victim, sort of navigating through the Nashville criminal justice system? It began with, I know you were very active in working with police to catch him. And then, we're still going through the court process because even though he's pled guilty, a defendant in Tennessee, if the sentence is under a certain amount of time, can file a motion to suspend the sentence and get it back in front of the judge, and the judge can actually agree to place the offender on probation or another alternative sentence when he was originally mandated to serve the entire sentence. So sort of take us through that briefly. And if there's anything you found particularly frustrating about the process, everybody on this panel is trying to make the justice system better for victims, so we'd love to hear it.
First of all, I was really fortunate to get Sergeant Pearsall, even the person at the front desk who, it took 3 events for me to be convinced that this was bizarre things like happening. And it was everyone along the way that kind of allowed me to summon the courage to continue to go back and do what was needed in order to get this temple off the street. I think that the frustrating thing was, I have a camera set up. I'm at my best friend's apartment, watching this guy in the back of, my house. And that wasn't, because I wasn't home, that wasn't good enough for it. That would have messed up his arrest or something along those lines, where it took another individual to make the call. If it wasn't for the other victim, that footage wouldn't have been enough to get him, to have him being taken to the, whatever I'm trying to say, arrested, or not arrested, but handcuffed, not off the street. So even still, he didn't come back the first night. I had to leave my car there, turn my lights on to almost lure him in. And that, it was very bizarre. I didn't think that was, that was a very interesting situation. I did not know that I didn't know you had to be in a vulnerable situation to make that even more. If I didn't have the good cops, I could have been in a really, really dangerous situation. But I would have had to have done that in order to get proof that he was doing what he had been doing that I had witnessed times before. So, as well as the going back in to court, that could have been really tough without the support that I was given by you, by Pearsall. I didn't know, besides, watching Law and Order, even what a courtroom looked like. I really was clueless. The advocate witness coordinator was always there, trying to explain what the process was. That was the only thing that allowed me to feel like I could fight, because I was so supported. And then, am I missing a question? I feel like I'm blanking.
No, you're good.
Okay. Besides the fact that I would have had to have been on the premises to make that situation real, and it not take another individual to make the call for a completely different thing down the road. It was just, that was the most frustrating.
Well, we really appreciate you joining us today, Mallory, and I think it goes a long way. Your voice has gone a long way So thank you for being here.
Thank you.
Mallory's case brings us to our next topic, and that is truth in sentencing. The phrase truth in sentencing means different things to different people, and it's worth mentioning that it is extremely expensive to achieve. On one hand, when a victim of a case like Mallory asks me, when will the defendant get out of jail and prison? The answer is always, it depends. It depends on the parole board and what they do. It depends on how many behavioral and program credits the person earns while in custody. And no one can really give an answer to a victim of when that date may come. And in my humble opinion, I don't think truth in sentencing necessarily needs to equate to lengthier sentences, but I think we can all agree that being able to tell a victim of crime that at least the month of release is a fundamentally fair thing to do. And I want to next go to a slide I put together to give the audience sort of a broad look at Tennessee's sentencing structure here. So if we take a look at this, let's start with just a routine example. Let's take a defendant who has had 0 prior felony convictions and has a sentence of 4 years at 30% to serve. After 30% of 4 years, the defendant would be eligible for release. Now, I think it's important to mention that just because the person is eligible for release doesn't mean that they're going to be released. It really depends on the parole board. But what this slide I wanted to sort of give you an example of is 100% of a sentence is very rarely served. And the last point, and as a general rule, if we go down there to that first asterisk, as a general rule, a defendant earns 2 days of credit for every day spent in custody for good behavior, participating in programs, etc. And I've listed some of the crimes below there in which a defendant must serve 75 to 85% of their sentence before eligible for release. And those are usually your violent crimes, your sexual crimes, crimes involving sexual abuse, physical abuse of a child. But I want everyone to see how this played out in Mallory's case. And I've created a slide here that equates to Mallory's offender's release date. So Mr. Temple was arrested on September the 1st of 2017 and received a 6-year felony sentence to serve at 60%. So even though he had 14 prior felonies, the highest I can mandate that he served before he's eligible for release is 60%. Now, there's also a 3.5-year sentence running consecutive to that. So what's important to know here is he had a total sentence of 9.5 years. What year will he be released? And if you said the beginning of 2027, you're off by more than 4 years. It stands to reason, right? If you have a 9.5-year sentence and you were in custody on 9/1/17, if you kick that out about 9.5 years, that would be the release date. So in actuality, Mr. Temple's current projected release date is next year, July 23rd of 2022. And so I want to go to District Attorney Wyrick for the last question of the panel. Do you foresee the possibility of the legislature coming up with a sentencing scheme that would enable a victim to know with more finality what the actual sentence would be?
I hope so. In my humble opinion, if the legislature does nothing else this year, let's do this. And it's one reason nobody wants to be prosecuted in the federal system, because if you get 10 years in the federal system, you're doing 10 years. And it's easy math for victims of those crimes to do, and those offenders. And as I said at the beginning of the program, we can do better as a state for both the Mallorys of Tennessee and all of the offenders who are sentenced to do prison time. I disagree a little bit with you in the sense that it doesn't necessarily have to cost more money, and it doesn't necessarily, I'm not advocating that if for whatever is a 20-year crime right now, continue as a 20-year crime. What we in the DA's conference, the bill that we have filed is to eliminate all of the statutes that currently exist that are responsible for the funny math, the 2-day credit that you talked about. I actually think in actuality right now it's up to as much as 4 days. They get 4 days for every 1 day that they've behaved well. They come into the Tennessee Department of Corrections system getting credit for every day they spent in my jail waiting to be convicted of their crime. And it's not 1 for 1. That's as much as 3 to 4 days for every 1 day that they get credit. So let's eliminate all of those statutes that contribute to the quagmire and the confusion. And let's have an honest conversation. Right now on the books, aggravated burglary, breaking into your home while you're at work today and stealing your hard-earned possessions. On paper, it looks like Tennessee says you should do 3 to 6 years for that. Well, you don't. And Jenny, you know it from your experience and all the lawyers on the screen. You do about 7 months if you do any time for that. So let's be honest about it. If that's what the legislature thinks home burglary is worth, 7 months, then let's put that on paper and let's be honest about it. So I hope that there is, if not a law that is passed at the end of this session, at least an effort by the General Assembly and everybody that needs to be involved in it to roll up our sleeves, put pen to paper, and get this done for the victims of Tennessee and for the offenders.
Thank you for that. So we are at 1:03 right now, and I wish we had more time for questions, but I'm going to pose the very first question, and then we're going to have to end. So this question is for Susanna. Why is a constitutional amendment necessary for Marcy's Law? Can these goals not be achieved through legislation? So Susanna, what do you have to say about that?
Yes, this is a fantastic question. So we like statutes. Statutes are wonderful. You can do some great things in statute. But if you want to think about a healthy environment for victims' rights, a robust victims' rights programs, think about constitutional rights as the bones and statutory enforcement as the muscles. Without the constitutional standing, without being recognized as legal equals to an offender, statutory rights don't, there is no way that those can ever become equal. We know this because the Constitution is where we put all the rights that we consider to be fundamental. No one here would be satisfied if your right to free speech or your right to worship or your right to bear arms were not spelled out in the Constitution. No one would be satisfied if those things were only statutory. And that's because statute, and this is a beautiful thing about statute, this is a good thing. You can tweak statute, you can change it, or you can completely erase it over the course of a legislative session. So General Wyrick's Truth in Sentencing bill, that's great because in one session you can go through and you can say, let's figure this out. Let's change what's on the books and let's make it different. We want victims' fundamental rights, the right to be notified, the right to be heard, to participate. We want those things to be really difficult to mess with. We believe those rights are fundamental. And the only place we can put them, the highest place we can put them is in the Constitution. So we need, so to answer your question, we need both. We need constitutional rights and we need statute to enliven those rights. But without constitutional rights, statutes don't get us to where we're trying to go.
I appreciate that. Thank you. And I want to just say thank you so much to all of our panelists for joining us. Thank you for our audience for joining in, and please tune into our website. We always offer very informative programs, fun programs of all different topics. And I hope everyone has a wonderful day. And again, thank you to all of our panelists who are working on behalf of victims in Tennessee.
Thank you so much.